Welcome viewers to Basics of Political Science. Before starting the video, I would like to take a few minutes from you. This is to make an announcement that from this video onwards, we would like to add an additional playlist wherein we would like to include some of the important videos that are related to Indian constitutions and Indian courts, or to be very precise, matter of facts of law. This is being done on a very intention that the Indian constitution is there in every aspect and in every syllabus and in every competitive exams. So please follow Basics of Political Science, wherein you will get all the videos, important videos regarding these kinds of matter of facts on law. So kindly subscribe Basics of Political Science. Thank you. Let us begin. The Supreme Court's 5-judge constitution bench on April 22nd held that providing 100% reservation for scheduled tribes in scheduled areas of a state is not permissible. The bench, comprising Justices Arun Mishra, Indira Banerjee, Vinit Saran, M.R. Shah and Anuruddh Bose, held that the reservation of 100% post was irrational and arbitrary and violative of Article 14 of the Constitution. Now let's see what was the background behind this kind of a judgment. Now let's see the background to this judgment. Paragraph 5.1 of the Schedule 5 to the Constitution of India enables the governor of a state to direct that any particular act of parliament or the legislature of a state shall not apply to a scheduled area or any part thereof in the state, subject to such exceptions or modifications as he may specify, even with retrospective effect. Now let us understand what is this Schedule 5 to the Constitution of India. As per the Constitution provision under Article 244(1) of the Constitution of India, the scheduled areas are defined as such areas as the President may by order declare to be scheduled areas, and this is as per paragraph 6.1 of the 5th schedule of the Constitution of India. According to this 5th schedule to the Constitution of India, the governor of a state in which there are scheduled areas can direct any act of parliament or legislature of a state subject of or a state list to be in kind of modifications or in any kind of a change within a normal act of parliament in a other non-scheduled areas or non-scheduled states. So in that case, the governor is empowered to direct such kind of a discretionary powers of himself. In 1986, the then governor of Andhra Pradesh, in exercise of this power only, that means this discretionary powers of the governor, directed the posts of teachers in educational institutions in the scheduled tribe areas of the state to be reserved for scheduled tribes only, wherein nothing withstanding contained in any other order or rule or law in force. So in 1986, the governor of Andhra Pradesh, by the use of his discretionary power, directed that all the posts of teachers in a certain area in Andhra Pradesh should be reserved for scheduled tribes only, because that area is coming under scheduled area as per paragraph 6.1 of the 5th schedule of the Constitution of India, and governor's discretionary power comes as per paragraph 5.1 of the Schedule 5 to the Constitution of India. In 1987, the direction was amended a little bit to allow the appointment of non-tribal people to hold the posts of the teachers in those scheduled areas till such time the qualified local tribal people become eligible for those posts. Challenging this, in 1993, non-tribals who were appointed as teachers and were expelled from their job and or rather terminated from their services, they challenged the entire thing in the High Court of Andhra Pradesh. After losing their case in High Court, the non-tribal teachers appealed in the Supreme Court in 1998 and the case was upheld. So, the Andhra Pradesh government in 2000 issued a fresh notification effectively providing for 100% reservation for STs in respect of appointment to the posts of teachers in the scheduled areas. Again, while the High Court upheld the validity of the 100% reservation, when it is challenged again in the Supreme Court, the Supreme Court's 5-judge constitutional bench, mind it, it's a constitutional bench consisting of 5 judges, on April 22nd, 2020, ruled or rather overruled against the High Court judgment. So, let us see what was basically High Court's argument was in providing the notification or the direction of the governors to be in favor of the Andhra Pradesh government. So, what was High Court's viewpoint and matter of law? The High Court had sustained the 100% reservation on the grounds that it would promote educational development of tribal people, considering the phenomenal absenteeism of the teachers in the schools situated in the scheduled areas. The High Court has held that in extraordinary situations, reservations could exceed 50% and that the governor possesses the power to issue the impunged notification under Schedule 5, Paragraph 1 of the Constitution. The same overrides all other provisions of the Constitutions, including Part 3, that is the fundamental right of the Constitution of India, which High Court had stipulated. In this scenario, the Supreme Court, however, disagreeing with the High Court, has held that the governor, in the exercise of the power conferred by Para 5.1 of the 5th Schedule of the Constitution, cannot provide 100% reservation. Now let us see what is Supreme Court's view on this overruling. What are the points where Supreme Court overruled High Court's judgment? According to Supreme Court, the governor, as per paragraph 3 of the Schedule 5 of the Constitution, has to submit a report to the President regarding the administration of scheduled areas annually or whenever so required by the President. So, the governor has to inform the President annually or whenever the time requires, has to inform the President in writing. So, the report is required to keep track of the progress in the areas. The report is essential for deciding to make reservation and for its review. The Supreme Court noted that the decision to reserve 100% of the posts was taken not on any kind of a verifiable data. So, there was no verifiable data, but on the basis that there was chronic absenteeism of non-tribal teachers in the schools in scheduled areas. The percentage of the ST population in Andhra Pradesh is 6%. The population in the scheduled areas not only includes scheduled tribes but also open category. So, scheduled castes and scheduled tribes settled after January 26, 1950, and they are not covered in the notification. The Supreme Court also observed no law mandates that only tribal teachers can teach in the scheduled areas. Thus, the action defies the logic. It is not the case that incumbents of other categories are not available in the areas. When a district is a unit for employment, the ground of phenomenal absenteeism is irrelevant and could not have formed the basis for providing 100% reservation. The problem of absenteeism could have been taken care of by providing better facilities and other incentives. The bench was of the view that 100% reservation would weaken the educational infrastructure and the merit and the standard of education imparted in the schools. It is an obnoxious idea that tribals only should teach the tribals. I quote what the bench has categorically said about this High Court judgment. So, the problem of phenomenal absenteeism of non-tribal teachers in tribal areas merits serious consideration and right remedial steps by the state government. The Supreme Court's observation that reservation by itself could weaken merit and the standard of education is not supported by facts but based on a naive understanding of merit and efficiency in public employment. Thus, in that case, Supreme Court also overrules on the ground that the High Court has not taken cognizance of the fact of the Indira Sohane argument of not exceeding 50% of the quota or the 50% of the reservation quota. This is also known as a Mandal Commission verdict, wherein the Supreme Court has seriously argued that there was no such special or relevant issue in which the state government can increase the quota from 50% or more than that of. It needs a serious evaluation of this kind of a matter of importance. Herein, the scheduled tribes who are there within a scheduled areas does not only constitute of a sole unit of employment. Thus, the Supreme Court negates all the 100% reservation quota by itself. Thank you.